I've had a lot of inquiries recently, people who have been disqualified over previous years. They've come to us and ask, well, can I get my licence back early? I've asked Conor to pop in today just to briefly summarise this area of law to you.
There are certain circumstances where you may be able to apply for the early removal of the disqualification. In other words, you get your licence back early. That doesn't apply in every situation. So not every person that is disqualified for drink or drug driving can apply for the licence back early. It has to fit a narrow criteria, a certain criteria that the court will work off. In summary, the disqualification has to have been at least a 3-year disqualification. If the disqualification was less than 3 years, there may be other options, and it's well worth contacting us to discuss those circumstances. We may be able to explain certain options that are open to you. But where the disqualification was 3 or more years, then you can, after a certain time period, apply for your licence back early. Now, Section 42 of the Road Traffic Offenders Act allows that to happen. So what Section 42 tells us is that where the disqualification was not less than 3 years, so 3 years or potentially more, you can apply for your licence back after 2 years. So usually between 3 and 4 years, you can apply for your licence back after 2 years. Now, that doesn't just mean submitting a form that you filled out, sending that to the court, and they'll give you your licence back. You usually have to go to court for that to happen. And there's a criteria that we have to comply with. There's boxes that we have to tick before that licence can be given back to you. And so the court, they want to know whether, since you were disqualified, have there been any change in circumstances? The change in circumstances could be that there's a job opportunity. It could be that there's a promotion. It could be that there's a change in family circumstances, parents that have become unwell, elderly parents that now need you to take them to and from hospital appointments. It could be that a child has arrived. So there's different circumstances that allow you to make that application to the magistrates, and they're usually looking for a change of circumstance. If there's no change of circumstance, it can make the argument much more difficult. But over 2 years, most people's circumstances will change in some way. So you can usually shape the argument to fit that criteria. The magistrates will also look at the reason why you were first disqualified. It would usually be a drink or a drug driving offence, and you would usually have to have a previous conviction. In almost every situation where somebody is handed a 3-year disqualification or more, it's because they have a previous drink or drug driving conviction within the last 10 years, and they therefore are given a mandatory minimum 3-year disqualification. So if you have a previous conviction, but you wanted to get your licence back early, don't think that makes it any less likely. Almost everyone that applies under Section 42 has got a previous conviction, and that's why they're able to apply under Section 42, because you have to have been given a minimum 3-year ban before you can make that application after a 2-year period. Now, as the disqualification increases, then so does the length of time that you have to wait. And we've set out quite easily on our website for reference the length of the disqualification and how long you have to wait before your licence can be given back to you early. We've also made a few other pointers as to the change of circumstances. Now, if you've not yet reached the 2-year point, don't think you just have to wait until 2 years before you then contact the solicitor. Always try and be as proactive as you can be. Now, we may not be able to get the case in court before the 2-year point, but if you're able to contact solicitors early on, then we can start preparing the case, building the argument, gathering any necessary evidence together, speaking with family, friends, getting witness statements, and really building a profile of an individual that now needs their licence back because of this change of circumstances, but also downplaying the previous offence, the reason why you've got that 3-year ban in the first place and any previous convictions before that. So it may be that we offer explanations as to why those offences were committed and the fact that you're a changed or rehabilitated person. So always try and contact solicitors before you hit the 2-year mark. We'll prepare the argument, make sure it fits the criteria, it's as strong and it's as compelling as it can be, and then when you hit the 2-year mark, of course, then we can make some contact with the court, try and get the case listed, and we're in court straight away, and that'll minimise the length of time that you spend disqualified any longer than you need to be, in excess of the 2-year mark. So again, a point at which you can apply does change for the length of disqualification that you're given. 3 years or 4 years, then you can apply back after 2 years. As the disqualification increases, you usually have to wait a little bit longer for that. But by all means, get in contact if you have any questions about the case. If you think you may be able to apply under Section 42 for the early removal of the disqualification, then please give me or Marcus or just give the office a call. And you're usually able to speak to a solicitor within a matter of seconds. We're able to go through things with you. We can discuss the case, discuss the options, and it's also worth pointing out that we generally work on a fixed fee basis as well, and that means that the costs are very clear from the outset. These cases aren't too complicated, and you're only ever going to have a maximum of one court hearing in most cases, in most circumstances, which means we can really limit and minimise the costs involved as well. And we've been doing this for a long time, so we know what's involved. But if you want to give us a call, we can go through the case with you, discuss the options, and then we can make a decision whether it's appropriate to apply under Section 42 to get that licence back for you as quickly as possible.